All rise. Veuillez vous lever. The mechanism for international criminal tribunals is now in session. L'audience au mécanisme pour le tribunal pénal international est ouverte.
Please be seated. Good afternoon. Registrar, could you kindly call the case?
Good afternoon, Your Honors. Case MICT 1699A, the prosecutor versus Vojislav Šešelj. Thank you.
Thank you, Registrar. In accordance with the scheduling order issued on 17 October 2017, the Appeals Chamber will hear today the prosecution's appeal against the judgment in the case of Mr. Vojislav Šešelj, rendered on 31 March 2016 by Trial Chamber 3 of the ICTY. For the record, I would like to note that Mr. Šešelj, who is elected to represent himself, is not present. Mr. Šešelj indicated in his response brief that he had no intention of participating in this appeal hearing. On 18 September 2017, the Appeals Chamber warned Mr. Šešelj that if he maintained his intention not to attend the appeal hearing, it would instruct the registrar to assign standby counsel to represent his procedural interests at the hearing. Mr. Šešelj did not respond to an invitation to reconsider his position in view of this warning. As a consequence, standby counsel was assigned who is present in the courtroom today. To preserve Mr. Šešelj's right to self-representation, standby counsel's mandate is limited to protecting Mr. Šešelj's procedural interests at today's hearings. Mr. Šešelj will be given an opportunity to respond to the prosecution's oral submissions within 10 days of receiving the BCS version of the transcript of today's hearing. Now we'd like to call for the appearances, please. First, counsel for the prosecution.
Good afternoon, Your Honors. My name is Mathias Markussen. I am appearing with Barbara Goy, Ms. Angel Danier, and Joshua Rosenwein. And our case manager today is Ian Reed.
Thank you.
Your Honor.
Mr. Markussen. Standby counsel for Mr. Šešelj.
Yes, good afternoon. This is Colleen Rowan, and I am appearing as standby counsel under the conditions specifically of the court's order.
Thank you very much.
Thank you.
I will now briefly introduce the matter before us today. This case concerns the acquittal of Mr. Vojislav Šešelj, who in February 1991 was appointed president of the Serbian Radical Party, and in June 1991 was elected a member of the Assembly of the Republic of Serbia. The prosecution charged Mr. Šešelj with persecution, deportation, and inhuman acts, forcible transfer, as crimes against humanity, as well as murder, torture, cruel treatment, wanton destruction of villages, destruction or willful damage of institutions dedicated to religion or education, and plunder of public and private property as violations of the laws or customs of war. The prosecution alleged that Mr. Šešelj planned, ordered, instigated, committed, or otherwise aided and abetted these crimes. It further alleged that he participated in these crimes between August 1991 and September 1993 by way of a joint criminal enterprise, the common purpose of which was the permanent and forcible removal through the commission of crimes of a majority of the Croatian, Bosnian Muslim, and other non-Serbian populations from approximately 1/3 of the territory of Croatia and large parts of Bosnia and Herzegovina and Vojvodina in Serbia, in order to make these areas a new Serbian-dominated state. The trial chamber, by a majority, Judge Latanzi dissenting, acquitted Mr. Šešelj of all charges. The prosecution advances two grounds of appeal, arguing that the trial chamber erred in law by failing to deliver a reasoned opinion and erred in fact by acquitting Mr. Šešelj. It requests that the appeals chamber revise the trial judgment to find Mr. Šešelj guilty as charged and sentence him accordingly, or, in the alternative, order a retrial. Mr. Šešelj responds that the prosecution appeal should be dismissed in its entirety. I will now summarize the manner in which we will proceed. I would like to remind the prosecution that the appeal process is not a trial de novo, and that it must refrain from repeating its case as presented at trial. The arguments must be limited to alleged errors of law, which invalidate the trial judgment, or alleged errors of fact, which occasion a miscarriage of justice. Throughout the hearing, the prosecution may argue the grounds of appeal in any order it considers suitable for its presentations. It shall present its submissions in a precise, clear, and concise manner, and should also provide precise references for material supporting its oral arguments. The judges, of course, may interrupt the prosecution at any time to ask questions, or they may ask questions following the submissions. The appeals chamber is familiar with the briefs, and I would therefore urge the prosecution not to repeat verbatim or to summarize extensively its written arguments. I would also like to remind the prosecution to be particularly careful not to reveal any information that could identify a protected witness. As set out in the scheduling order, we shall hear the submissions from the prosecution for 1 hour. Since Mr. Šešelj has elected not to participate in the hearing will then conclude. Now I would like to invite counsel for the prosecution to present the appeal. Counsel for the prosecution.
Thank you, Your Honors. Your Honors, justice has not been done in the case against Vojislav Šešelj. This is not only because Vojislav Šešelj was acquitted, although we have demonstrated in our appeal brief that no trier of fact could have acquitted him. No, the much more worrying problem is that the trial chamber failed to properly adjudicate the case. We therefore find ourselves in the situation where we do not have a reasoned judgment. In our first ground of appeal, we have identified numerous errors in the adjudication. Each of them undermine the verdict. But by far the most concerning error is the failure of the trial chamber to discuss and analyze voluminous evidence in the trial records about the crimes committed in Bosnia, Herzegovina, and Croatia. how could a judgment be written without consideration of the evidence of crimes? How could there be a determination of whether or not there was a joint criminal enterprise if the evidence of crimes was not considered? How could there be findings about the widespread or systematic attack against the civilian population if the scale and pattern of crimes was not considered? How can the victims and witnesses be sure that justice has been done if the evidence of the crimes is not discussed in the judgment? The answer, of course, is that the evidence about the crimes in Croatia and Bosnia and Herzegovina was central to the case. A judgment could not be written without giving it thorough consideration. And Your Honor, the judgment barely mentions the evidence of the crimes in Croatia and Bosnia and Herzegovina. Of the 357 paragraphs in the judgment, there are only 10 that deals with the evidence of the crimes in Croatia and Bosnia and Herzegovina. Only 7 paragraphs deal with the massive war crimes committed against Croats, Muslims, and other non-Serbs during the ethnic cleansing campaigns in Croatia and Bosnia and Herzegovina. 7. Merely 2 paragraphs are devoted to the stunning conclusion that there was no widespread or systematic attack against the civilian population in Croatia and in Bosnia and Herzegovina. 2. The section of the judgment dealing with joint criminal enterprise responsibility has 1 cursory paragraph about crimes. 1. There is no analysis anywhere in the judgment of the evidence of deportation and forcible transfer of the Croat and Muslims from Serb-claimed areas. That was the objective of the common criminal purpose. None. This is not a judgment by the ICTY and MICT standards. It must be quashed. Letting it stand will undermine the credibility both of the ICTY and the MICT. The prosecution's first round of appeal demonstrated numerous errors in the judgment arising from systematic failures to provide a legal opinion. Those errors are so pervasive that the prosecution's case has not been properly adjudicated. Today, I will give 4 examples of failures by the trial chamber to exercise its judicial functions. The first is that the trial chamber failed to exercise its primary function of assessing the credibility of significant evidence in the trial record. The second is that the trial chamber did not consider Šešelj's intent when it considered his participation in the common criminal purpose. The third is that the core charge of the indictment has not been adjudicated because the majority misconstrued the prosecution's case. And fourth, and by far the most concerning, the majority failed to consider the vast volume of evidence of crimes, and the findings on the crimes that were considered are deeply defective. Let me turn to the first point. It is axiomatic that one of the most important duties of a trier of fact is to assess the credibility and reliability of the evidence in the trial record. As the ICTR appeals chamber in the Intagerura case or judgment said at paragraph 174, quote, "At the first stage, the trial chamber has to assess the credibility of the relevant evidence presented," end quote. Yet, there are barely any analysis of the credibility of findings on the credibility of evidence in the judgment. In the appeal brief, paragraphs 14 to 17, we have given 2 examples of missing credibility findings. First, at trial, a number of witnesses recanted their prior statements to the prosecution and alleged that the prosecution had forced them to sign false statements. The trial chamber appointed an amicus curiae to investigate, who concluded that it was not the prosecution who had interfered with the witnesses. And with respect to one witness, Stojanovic, the chamber stated that the recantation of his prior statements, quote, strained credibility, end quote. So there were clearly significant credibility questions that had to be answered with respect to each of the recanting witnesses. Yet, there is no credibility analysis of their evidence in the judgment. And the decision, the strained credibility decision, is a decision from the 11th of September 2008. And second, the trial chamber frequently refers to the transcript of Šešelj's testimony in the Milosevic case and seems to accept his self-serving denials. But nowhere in the judgment is there any discussion of Šešelj's credibility. There is no discussion of the fact that Šešelj was indicted when he testified and therefore had an incentive to exculpate himself. There is no assessment of the credibility of his testimony in light of other evidence in the record. Such important evidence should have been scrutinized. It was not. I would like to stress that these two examples given in our appeal brief are not the only ones. In fact, there are virtually no credibility findings in the judgment at all. The trial chamber received evidence from almost 100 witnesses. It made credibility findings about only 8 individual witnesses in paragraphs 22, 23, 244, 333, and 341. One will search in vain for findings of the credibility on the credibility of any other witnesses in the judgment. The near total absence of findings of credibility of the evidence in the trial record proves a breakdown in the adjudication of the case. The second serious flaw in the adjudication is the trial chamber's failure to adjudicate the prosecution's case about Šešelj's intent to participate in the common criminal purpose. As we have shown in paragraphs 26 to 41 of the appeal brief, the trial chamber failed to consider voluminous evidence that Šešelj repeatedly and explicitly expressed his intent to achieve the common criminal purpose through violence. His calls for population exchanges, his declarations that Serbs and Croats can no longer live together, his incitement that stroked fears among Serbs that they were under threat, his calls for revenge for past crimes, and his promise that rivers of blood would flow if Bosnia and Herzegovina were to declare independence. These statements and other evidence of Šešelj's intent should clearly have been considered in determining whether he shared the common criminal purpose to forcibly remove non-Serbs through the commission of crimes. They were not. Moreover, the trial chamber did not even consider the finding in paragraph 338 of the judgment that some of Šešelj's speeches were, quote, barely disguised calls for expulsion, end quote. Surely, this demonstrates Šešelj's intent to forcibly displace. But another majority, composed of judges Antonetti and Young, found that this could be construed as, quote, an expression of an alternative political program that was never implemented, end quote. The finding that Šešelj's political program included expulsions of Croats must surely entail that Šešelj had the intent to expel Croats. The expulsions of non-Serbs was the common criminal purpose alleged in the indictment. However, the majority never even broached the issue of its findings in the JCE analysis. the majority's failure to consider a large body of clearly relevant evidence, or even the impact of its own findings, demonstrate that a central issue in the case has not been properly adjudicated. The third serious problem in the judgment is that the prosecution's core argument about why the evidence proved the existence of a common criminal purpose was not properly adjudicated. The majority claimed that the prosecution's core argument at the end of the trial was unclear. It then recasted it, suggesting that the prosecution argued that the establishment of Serb authorities in Serb-claimed areas, the arming, training, and use of Serb forces to establish territorial control was illegal. It then came to the unsurprising conclusion that these activities were not illegal. In doing so, the trial chamber failed to address the prosecution's actual case, which was that the large number of crimes proved the existence of the common criminal purpose. The prosecution's core argument was that Serb forces, including Šešelj's men, launched a large-scale ethnic cleansing campaign in Croatia and Bosnia and Herzegovina, during which they systematically expelled tens of thousands of non-Serbs, and killed and tortured and beaten and mistreated and unlawfully detained in inhumane conditions thousands of others. Non-Serb property was looted and destroyed. Discriminatory measures forced non-Serbs to leave and prevented those who have been expelled from returning. These systematic mass atrocities by Šešelj's men and other Serb forces were all directed against non-Serbs in the territory that Šešelj and other JCE members claimed. This allowed for only one reasonable conclusion. The crimes in the indictment were committed pursuant to a common criminal purpose. This was the core allegation that had to be adjudicated. It was not. We have addressed the majority's deeply worrying failure to adjudicate the prosecution's main legal theory in paragraphs 75 to 108 of our appeal brief. But I would like to add that even if the prosecution's final submissions had been unclear, it was the charges in the indictment that the trial chamber had to adjudicate. And the indictment was clear. As early as 26 May 2004, the trial chamber, at that time composed of Judge Aegis presiding, Judge Antonetti, and Judge Parker, found that paragraph 6 of the indictment pled the common criminal purpose of the joint criminal enterprise with sufficient clarity. At the time, paragraph 6 of the indictment defined the common criminal purpose as, quote, the permanent forcible removal through the commission of crimes, end quote. The operative third amended indictment reads exactly the same. So the majority's purported confusion regarding the nature of the common criminal purpose demonstrate a failure to adjudicate the core aspect of the prosecution's case. And this brings me to by far the most concerning problem with the adjudication of the case: the missing analysis of the evidence of the crimes committed throughout Croatia and Bosnia and Herzegovina. As I mentioned, of the 357 paragraphs in the judgment, only 10 discusses evidence of crimes in Croatia and Bosnia and Herzegovina. How is it possible? By comparison, the majority expends 15 paragraphs discussing a debate between the judges and prosecution counsel in the Milosevic case, which is not evidence let alone evidence in this case. But even the few findings in the judgment about crimes are deeply problematic. They lack reasons, and they leave crimes floating in isolation without any discussion of their context. Your Honors, on the screen you now have paragraph 210 of the indictment, and I'm not, excuse me, of the judgment, of course. I'm not suggesting you try to read it. I am really just putting it up here to illustrate that it is merely a list of bullet points. And if we go to the next slide. Okay. Sorry, so it's merely a list of bullet points which provide no explanation for how the findings were made. They're mere conclusions. And if we go back to the slide we just saw, thank you. And Your Honors, the footnotes to this bullet point list cites to a total of 13,480 pages of evidence. And Your Honors, on the screen you now see the two first footnotes to paragraph 210 of the judgment. As you can see, there's simply a long list of evidence citing bulk documents and witnesses without a single page reference. The trial chamber does not even say whether it relies on witnesses' prior statements or their live testimony. The first reference says decision of 23 July 2010 annex. That is an adjudicated fact decision admitting 155 facts extracted from the Kreisnig case on a number of different matters. How do we know what facts the trial chamber relied on and for what findings? The second reference is to Renaud Toynens. He was the prosecution's expert, military expert. His report is 397 pages long. His testimony runs over 637 pages. He was cross-examined by Šešelj. The judges had numerous questions to him during his testimony. What did the trial chamber rely on? How did it assess the evidence? There's no way of knowing. Your Honors, the other paragraphs with conclusions on war crimes follow the same format, with mere bullet points and string cites to extensive evidence in the footnotes. By no stretch can these paragraphs be called a reasoned opinion. They are the opposite of a reasoned opinion. A conclusion without any explanation. Your Honors will also note that the war crimes are not explained in their proper context. The trial chamber chose to spend 154 paragraphs making findings on the political and historical context of the case, various political parties, and Serb armed forces. But there is not a single reference to the crimes committed by those Serb forces during the events discussed. For example, in paragraph 91 of the judgment, the trial chamber finds that between the 1st of April and the 15th of June 1992, the municipal and regional organs of the SGS played a major role in organizing TO units. These units, sometimes operated with the JNA, proceeded to secure Serbian municipalities. The crimes in Zvornik that we just took a look at were committed exactly during this period of time by Šešelj's men, Arkam's men, local territorial defense and police units, supported by the army. Why is there no discussion in the judgment of what this might prove? It was the main point of the prosecution's argument at trial that the consistent pattern of large-scale crimes systematically committed in the areas taken over by Serb forces, created and controlled by Šešelj and other JCE members, could lead to only one reasonable conclusion, namely that the crimes were committed as part of the implementation of a common criminal purpose. The failure to place the crimes in their context is further proof that key issues in the case have not been adjudicated. Finally, I would like to turn to paragraphs 192 and 193 of the judgment, where the trial chamber comes to the stunning conclusion that the prosecution had not proven that there was a widespread or systematic attack against the civilian population in Croatia and Bosnia and
Mr.
Herzegovina.
Markuson, before you turn to that, thank you for your argument. In your appeal brief, and today you argued that the trial chamber erred in failing to provide a reasoned opinion in relation to its findings on violations of laws and customs of war. Could the prosecution clarify the impact that the trial chamber's error, which you have been discussing, may have on the verdict and on the remedy that you seek?
Your Honor, the prosecution has appealed as a matter of principle all findings that are not recent. So the trial chamber, with, as I said, using the same unreasoned conclusions, found that a number of crimes were not proven. Those errors impact on the acquittal, of course. But we cannot have the cake and eat it as well. The same problems in reasoning and lack of reasoned opinion also applies to the crimes that were actually found proven. So we have appealed all the findings. We can't show an impact directly, but we have to accept that the problem is systemic in the judgment.
Thank you.
Yeah, so I would like to turn to paragraphs 192 and 193, where the judges find that there was not evidence of a widespread or systematic attack against the civilian population in Croatia and Bosnia and Herzegovina. This is a stunning finding. The witnesses and the victims were entitled to an explanation so they can understand how the trial chamber could come to a conclusion at odds with dozens of other judgments rendered by the ICTY. The majority offers none. It does not even cite to a single piece of evidence in paragraph 192. Instead, it merely refers to, quote, the totality of the evidence, end quote. But as the appeals chamber in paragraph 433 of the Ptolemyer case, its judgment in the Ptolemyer case, have made clear, mere reference to the totality of evidence without further explanation is not enough to provide a reasoned opinion. But moreover, we know that the trial chamber did not consider all the evidence in the record. First, I would like to draw your attention to an omission in the judgment that is so blatant that one risks to overlook it. It is the failure to even acknowledge the existence of the evidence of the crimes of deportation and forcible transfer found in the trial record. It is simply not mentioned anywhere in the judgment. Yet, the alleged common criminal purpose was the permanent forcible removal of non-Serbs from targeted areas. The evidence proves that tens of thousands of people were forcibly expelled from the areas they lived in. The case could not be adjudicated without consideration of this evidence. It was central to establishing whether there was a common criminal purpose and whether a widespread or systematic attack against the civilian population had been proven. And second, the majority explicitly excluded evidence from the so-called pattern municipalities from its consideration at paragraph 29 of the judgment. This ruling directly contradicts John Antonetti's 20 September 2007 decision as pre-appeal judge that the pattern of evidence was, or that the pattern evidence was relevant, among other things, to whether there was a widespread or systematic attack and to JCE liability. But remarkably, the majority did not consider it relevant because it, quote, merely duplicates very similar accusations, end quote. But that is, of course, the whole point of pattern evidence. It is the similarities that prove the pattern, and from the pattern that correct inferences are drawn. As the trial chamber in the Perlich et al. Case has explained, quote, it is the patterns of crimes in the sense of the deliberate, regular repetition of similar criminal conduct that one, excuse me, I think I have to read that again. It is in the pattern of the crimes in the sense of the deliberate, regular repetition of similar criminal conduct that one discerns their systemic character. I'm sorry, Your Honors. End quote. Volume 1, paragraph 41. The trial chamber also did not consider dozens of facts that it had taken judicial notice of that clearly proved that indeed there was a widespread or systematic attack against non-Serbs. For example, adjudicated fact AF, Roman 1, fact number 172, which says the following about Bosnia. In general, the military takeovers involved sniping, shelling, sniping, and the rounding up of non-Serbs in the area. These tactics often resulted in civilian deaths and the flight of non-Serbs. The remaining non-Serbs were then forced to meet in assembly areas in towns for expulsion from the area. Large numbers of non-Serbs were imprisoned, beaten, and forced to sing Chetnik songs, and their valuables seized. This was accompanied by widespread destruction of personal and real property. Despite its statement to the contrary, the majority did not consider the evidence in its totality. It did not even consider what inferences might be drawn from the numerous war crimes that it had found proven in paragraphs 207, 210, 213, 216, and 219. I earlier mentioned paragraph 210 about the crimes in Zvornik. The war crimes that the trial chamber found established in that paragraph alone prove that there was a widespread or systematic attack against the civilian population there. The crimes proven in the paragraph shows a large-scale campaign of crimes committed by Serb forces from they took over Zvornik town on April 8, 1992, until all Muslims had been expelled in June 1992. Overall, the evidence shows that 1,080 persons were killed in Zvornik. 165 of those are identified by name in our final trial brief. The trial chamber found the murder of a large number of Muslim detainees at Karakai Technical School and the murder of a large number of non-Serb detainees at Gero's slaughterhouse. It did not make findings on the number of victims, but the evidence proves that at least 740 were killed at those two locations. And the chamber also itemized 67 other murders in Zvornik. The chamber further found that acts of torture, cruel treatment were inflicted on the Muslim detainees in numerous detention facilities run by certain forces, such as the Standard Shoe Factory, Economia Farm, the Siglana Factory, Drinjata Dom Cultura, Karakai Technical School, and Chelopek Dom Cultura in May and June 1992. The large-scale, protracted and systematic nature of the crimes in Zvornik prove a widespread or systematic attack against the civilian population. And of course, it was not just in Zvornik that such crimes were committed. The war crimes found proven in Vukovar, the greater Sarajevo municipalities, and Mostar and Nevesinje follow the same clear pattern. Finally, I would like to draw your honor's attention to the last part of paragraph 193 of the judgment, which conclude the majority's findings on the widespread or systematic attack. There, the majority gives credit to Šešelj's argument that buses were provided not as part of an operation to forcibly displace the population, but rather as, quote, acts of humanitarian assistance to non-combatants fleeing the zones where they no longer felt safe, end quote. The majority cites limited portions of the evidence of two witnesses as sufficient to prove that there could be something to this stunning proposition that buses were provided as a humanitarian gesture. The majority cited to evidence that is not in public, so regrettably I cannot discuss it today. But I refer your honors to paragraph 51 to 57 of our appeal brief, where we demonstrate that the majority took the witnesses' evidence so badly out of context that it directly reversed what it proved. And the evidence in the record shows that Šešelj himself was advocating expelling busloads of non-Serbs from areas that he considered Serb in order to change the demographic composition of those areas. Speaking of Croats in Serbia, he said, quote, perhaps the best solution, if they pity the Croats so much, would be simply putting them on buses and trucks and taking them to Zagreb, end quote. And, quote, Croats have no business in Serbia. Anyone calling for human rights and civil liberties can look for them in Zagreb. We will simply see them onto the buses and see them to the border, end quote. This is from Exhibit P75, page 7, and Exhibit P1298, page 1. And the evidence shows that this is exactly what happened in the crime-based municipalities. Victims were forced onto buses that moved them out of Serb territory, or to detention centers where they were brutalized after their homes, villages, and sacred places had been destroyed and members of their families murdered. At the time of the events covered by the indictment, the European Community Monitoring Mission to the Balkans described the crimes in Croatia up until November 1991 in the following way. Quote, throughout broad areas of territory, in innumerable smaller villages, Croatian inhabitants are killed or forced to leave after their villages are bulldozed out of existence. They are simply and wantonly destroyed. End quote. That is Exhibit P412 at page 13.
Excuse me, Mr. Markussen, are you planning in the remainder of your presentation to refer specifically to some of the speeches of Mr. Šešelj, such as his speech in Vukovar and his speech in Hrtotski? And if not, I would like to ask you a question about it.
I was not, our submission, this is covered extensively in our brief. We are happy to address them more, but we were focusing today on the biggest errors in the judgment that we submit demonstrate a failure to adjudicate. In our brief, as I said earlier, we have discussed in some detail a number of the speeches that we have said the trial chamber should have considered, not only the ones in Hrtotski and Vukovar, but a number of other speeches that were not considered by the trial chamber.
So let me ask you a question or two, which is not perhaps clearly covered in your briefs. First, with regard to Vukovar, in your appeal brief, you submit that Mr. Šešelj triggered the crimes in Vukovar when he instructed Serbian forces that, and I quote, "No Ustasha should leave Vukovar alive." The prosecution argues that no reasonable trier of fact could have found that Mr. Šešelj's statement did not amount to persecution as a crime against humanity. In paragraph 318, the trial chamber did express doubts about the exact content of the statement of Mr. Šešelj, and despite this different vision of that by the trial chamber, in your appeal brief you do not clarify this matter. If it's not difficult, I would appreciate if you would say something about it. Let me ask you one more question regarding speeches. And I now refer to the question of the instigation by Mr. Šešelj of crimes in Hrtotski. In your appeal brief, you argued that no reasonable trier of fact could have concluded that Mr. Šešelj did not instigate the crimes in Hrtotski by substantially contributing through his speech to the commission of those crimes. it would be helpful to the bench if you could give us some specification of the individuals whom Šešelj is alleged to have instigated and who later perpetrated the crimes in the Krtovci, if this information is available to you.
Your Honors, in Herkovci, the speech was given at a rally with a number of local Serbs. And following the speech, there was a considerable increase in the acts of intimidation and violence against the Croat population. And the evidence also identify a number of members of Šešelj's party in the area who participated in these events, or in this intimidation. So our submission is that it is clear from the totality of the evidence, the increase in the crimes that were committed or the intimidation after the speech, that there's a causal relationship between the speech and the acts against the Croat population. And we have identified in the evidence of VS 67 discuss this in more detail, and I would refer your honors to paragraph 203 of the appeal brief, where we cite more specific evidence on this point.
So you have some names there, right?
Yes, VS 67 explained that he VS 67 evidence was that he Oh, sorry. Now I understand what my colleagues are drawing my attention to. They are drawing my attention to the fact that I cannot tell you because the evidence is under seal and was given in closed session. But if your honors would look at the last sentence of paragraph 203 of our appeal brief, there is an explanation, there's an answer to your question. It feels a little unset.
That's quite helpful. Now, with regard to the first speech I mentioned, Vukovar.
There, the evidence of, I think that your question, I think, if I understood it correctly, raised there were two aspects to it. One is whether the contents of the speech was actually proven. Did you understand that correctly? Yes.
Well, the trial chamber did have hesitations about it.
Yes.
And I would have liked your clarification
Yes.
as to what's your comment on their hesitations? They felt that there were some doubts about the content of that speech.
Your Honors, there were multiple witnesses who gave evidence about the speech. They gave slightly different nuances of the exact wording of the speech, and we have a journalist who actually had a note, his note of the speech in question. So we submit that the trial chamber was wrong in finding that there was any doubt that Šešelj had given the speech in question and of the nature of what he had said. So there might have been slightly different wordings of the speech reflected in the evidence, but there can be no doubt that the speech was made and what the nature of the contents was. And Šešelj gave this speech in a location where a number of his volunteers were present. At the time when Croats were being killed and murdered, for example, in the Velipromet facility that was controlled by local TO forces and his volunteers. So we submit there's a quite clear causality between Šešelj's statements, which of course also follows numerous similar statements not made in Vukovar but in other places. It was sort of Šešelj's whole persona to make these statements, and his message was very clear. One of the witnesses in the case that we cited in the brief says that it made his blood freeze when he heard the speech because he knew what it meant. So the speech was very clear.
Thank you, Mr. Melkers.
So, Your Honours, I just quoted from the European Community's monitoring missions to the Balkans about the nature of the ethnic cleansing campaign in Croatia, which later continued in Bosnia. And it was these crimes that made the term ethnic cleansing part my colleagues kindly point me to paragraph 182 of our appeal brief, where the witness who talked about the impact that Šešelj's speech had on him is cited. Excuse me 1 minute, Your Honor. Your Honors, it was the massive crimes of deportation and forcible transfer that made the term ethnic cleansing part of the vocabulary of a new generation, and it was the reason why the ICTY was created. The majority's suggestion that buses might have been provided as a humanitarian gesture is an insult to the victims and the witnesses who testified before the trial chamber. The appeals chamber must intervene. The errors demonstrated in ground 1 of the prosecution's appeal brief are serious and they are pervasive. As a result, we do not have a reasoned judgment. And as the examples I've discussed today demonstrate, the trial chamber failed to render credibility findings. It did not adjudicate core issues in the case. It failed to consider a large body of evidence that proved the core crimes of the common criminal purpose and the widespread or systematic attack that this case was about. Letting the judgment stand is not only an affront to the victims of the alleged crimes, but it also would seriously undermine the credibility and legacy of the ICTY and the MICT. The entire judgment is so flawed that it must be quashed and the acquittal overturned. Once the judgment is quashed, Your Honours can exercise your discretion in a number of ways. Your Honours can intervene by assessing the evidence and making the necessary findings and entering a conviction yourself. The appeals chamber has the authority to do so and has exercised this authority in other cases. The appeals chamber can enter findings and convictions based on the existing trial record. But the prosecution recognized in its appeal brief at paragraph 251 that the ICTY appeals chamber in the Stanisic-Smatovic case was of the view that it could not do so. If Your Honours consider that an analysis of the trial record would be inappropriate without having directly heard the witnesses, then a retrial is the appropriate avenue. The prosecution also recognizes that the ICTY Appeals Chamber recently found in the Perlitz case that it would not be appropriate to conduct its own analysis of the trial record. In so doing, it considered that numerous convictions were upheld and the long sentences that were imposed, as well as the length of the proceedings, and found that it would not be appropriate to order a retrial in relation to the crimes where the trial chamber had erred. A similar approach would not be appropriate in this case, because the serious charges against Vojislav Šešelj have not been properly adjudicated. For this reason, whichever way your honors exercise your discretion, we urge you not to stop at the finding that the trial chamber erred. The judgment should be quashed and the acquittal overturned. If your honors were to dismiss the prosecution's first and principal ground of appeal and find that the judgment is sufficiently reasoned and that the case has been correctly adjudicated, then your honors should grant the prosecution's second ground of appeal. With respect to the prosecution's second ground of appeal, we rest on our appeal brief. Thank you, your honors. Subject to any further questions you might have, this concludes the prosecution's submissions.
Ask whether any one of my distinguished colleagues has questions. None. So I take it that standby counsel has no comments on the procedural aspects of Mr. Šešelj's rights. So in this case, this concludes the hearing of. Terribly sorry.
Sorry, just while we're still in session, at page 2, line 9.
Sorry?
In the transcript at page 2, line 9, I think there's a mistake. I introduced Ms. Barbara Goy as counsel on the case, but the transcript says Lisa Biersay, who was one of the distinguished members of the trial team at the time.
Thank you for.
Thank you, Your Honor.
Thank you for this correction. Of course, we know Ms. Goy. So, as I was saying, this concludes the hearing of the appeal in this case. I remind the parties that in accordance with the scheduling order of 17 October 2017, Mr. Šešelj's response in writing to the prosecution's oral submissions, if any, will be due within 10 days of receiving the BCS version of the transcript of this hearing. And the prosecution reply will be due within 5 days of receiving the English version of Mr. Šešelj's response. Before we adjourn, I would like to take this moment to thank everybody for their work on this case. I would also like to express, and especially the prosecution, I would also like to express my gratitude to the registry, who have so ably facilitated our hearing today, and to the interpreters for their excellent assistance. The Appeals Chamber will render its judgment in due course, following receipt of the written submission from Mr. Šešelj, if any, and the written reply of the prosecution. We are adjourned.
All rise.